All right, and we're back. Okay. So, our next segment here, we have our Deputy District Attorney, Steven Swikert, is going to help you with the, some of these requirements of open meeting law, abstentions, ethics, some of those really interesting and very necessary issues and things to talk about. So, Mr. Steven Swikert. Thank you, sir. I'm sorry. And then here's your clicker right here. Okay. Right is to advance.
Good morning, everyone, and welcome back from the break. My name is Steven Swikert. I'm a Deputy District Attorney. I work in the Civil Division of the DA's office. I'm not a criminal prosecutor. I've been with the county for about 20 years. I advise on town services as well as the Public Response Office, which enforce the zoning laws, so you may end up getting to know them.
Closer.
Thanks. The subject of today's presentations is ethics, open meetings, laws, and bylaws. I was also asked to cover abstentions. And I will not be addressing that as a separate topic, but I will be discussing it in relation to the open meeting law and ethics. As we go along, please feel free to interrupt me and ask questions, and I'll provide answers as I can. There'll probably also be some time at the end for questions and answers. Ethics are behavior that include voting issues and how the meetings are held, and include such things as disclosures and abstentions and quorums. The open meeting law concerns the manner over which the public meetings are held, and includes such things as agendas, other notices, and posting of notice. Training is required for both for town advisory boards and citizens advisory council, and so that's why I'm here today. Bylaws are rules for conducting the meetings, and they include such things as parliamentary procedure and choosing officers. A couple points before I begin. While you're here, don't discuss... Oh yeah, you have my handout? Good, okay. I'm glad. I provided a handout, so you each should have a copy of that. It basically just goes over the things I'll be saying today. Bylaws, let's see, a few points before I get in. Don't talk about advisory body business. Because there's a quorum for each of your town boards and advisory councils today, if you start talking advisory business, you'd likely violate the open meeting law. So we want to avoid that so we don't get in trouble. Also, the Board of County Commissioners has resolved that this presentation be presented in a layperson-friendly language, so that if I get too technical, just let me know and I'll tone it down. Don't throw any rotten tomatoes. Ethics, they can be pretty complicated, and they're addressed by many different laws and policies. There's the county ethics policy, the ethical standards set forth in the Clark County Code in section 2.42. They're covered by NRS chapter 281A, as well as your bylaws briefly touch upon ethics. The good news is I'm not going to get into the complications of these. But the better news is that the ethics can be summarized because most of the laws and policies say the same thing and as a general matter. What are the policy objectives of the ethics laws? Those are treating those persons and entities that deal with the government with impartiality, fairness, and equality, assuring that decisions of public importance are not influenced by private considerations, maintaining public confidence in government, which implicates the appearance of impropriety, and preventing the use of public office for private gain. Ethics summarized. Except for a few things, this will mostly be a bunch of don'ts. Avoid even the appearance of impropriety to keep the public trust. Don't seek gifts or improper influence, unwarranted privileges or preferences. Be careful about doing deals with the government or private deals which also involve the government. Don't accept money from private sources for your public duties. Don't use insider information for personal gain. Don't suppress any reports. Don't use government property improperly. Don't influence staff for personal gain. And when in doubt, ask for help. NRS 281A.020 provides very good and clear direction. A public officer or employee must commit himself to avoid conflicts between his private interests and those of the general public whom he serves. The increasing complexity of state and local government, more and more closely related to private life and enterprises, enlarges the potentiality for conflicts of interest. I would also add that social media also increases the complexity of these matters. But I'll have more to say about social media in a little bit. As I said before, ethics laws are not just about avoiding conflicts of interest, but about avoiding the appearance of impropriety. That's because it's necessary to maintain the public trust in government. Let's see, advice, reporting, and sanctions. If you have a concern, contact your liaison first, and if she's unable to address it, he or she, then they can consult the DA's office and we can sort the matters out. There's several laws that cover ethics, and there's also ethics commission's opinions that could provide the answers to your ethical dilemmas. However, the ethics commission does not oversee the town advisory boards, so you don't need to worry about being punished by the ethics commission for a violation, as advisory bodies are expressly excluded from the ethics commission oversight. Concerning sanctions, because it's in the Clark County Code, Chapter 2.42 that covers ethics, any violation of it is a misdemeanor, which can result in a fine of up to $1,000 and incarceration in jail for up to 6 months. Now, it's unlikely that anybody's going to be prosecuted for that, but it is possible, particularly now that we have town boards that are elected. Because the Board of County Commissioners can't remove such persons, whether elected or appointed, for at their pleasure. All other town advisory boards and citizens advisory councils do serve at the pleasure of board and can be removed for a violation or even questionable conduct. Disclosure of actual and potential conflicts of interest. Disclosure can resolve a lot of problems. It can help frame the situation so that the public knows what's going on, but it could also remove the appearance of impropriety. Disclosure is only required if there is an actual conflict of interest, but if you're encouraged to disclose if there's even the appearance of impropriety. You must disclose gifts, loans, and other financial and personal interests. Disclosure must be made with sufficient information so that the public can understand what the situation is. And disclosure must be made at the time of consideration of the relevant item. You don't need to disclose to your liaison several days in advance of the meeting. You need to disclose while the matter is on the agenda and ready for consideration. And you should disclose assuming that the public doesn't know anything about you. So there should be quite a bit of detail in your disclosures. Abstentions due to conflicts of interest. Disclosure by itself does not require abstention from voting, but to abstain for a conflict of interest, you must first disclose. Otherwise, that's a violation of the law. Abstention is required if a hypothetical reasonable person would have his independence of judgment materially affected. And disclosure helps frame that hypothetical person. Abstention is not required for a general benefit, such as to vote to lower everyone's taxes. Abstentions should not be lightly made because you have a responsibility sitting on the board to vote and to deliberate so that the public can hear your reasoning on matters. You must disclose why you will or will not abstain, and that's going to be dependent upon what your disclosure is, but also stating that you've consulted with your attorney or with your liaisons and reached the conclusion that abstention is or is not appropriate. If you abstain, don't participate in the discussion at all. Even a mere recitation of facts can be considered as improper advocacy. I was asked in the past if you can abstain while you're sitting on the board and then during public comment period present your arguments. And the answer is no, you can't do that. That would still be improper advocacy. Your hats aren't so easily interchangeable. Abstention, if required, reduces the number of members in the membership of the body, and so will reduce the quorum requirement. I'll have more to say about quorums in a bit. A commitment to others that can require disclosure include others who are members of your household, those related by blood, adoption, or marriage, employers of members of your household, and those with other substantial and continuing business relationships and similar important interests. Now on to the Nevada Open Meeting Law. The most important section, I believe, is the first. The legislative intent is covered by NRS 241.010. In enacting this chapter, the legislature finds and declares that all public bodies exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. So no smoke-filled back rooms. I've missed some of my slides here. Sanctions. Go to jail. So no smoke-filled back rooms or many backroom deals, smoke-filled or not. All other sections of the NRS Chapter 241 are designed to implement that legislative policy. Topics covered by the law include such things as what are public bodies covered by the Act. As advisory bodies, town advisory boards, and citizen advisory councils are expressly covered by the law. It covers what are meetings that fall within the open meeting law, what special rules apply to providing notice to the public. This includes such things as agendas and how the agendas are posted, as well as, in some circumstances, notice to individual persons. It covers whether or not emergencies can justify suspending notice. As advisory boards, I don't think you'll ever come across any circumstances where there would be an emergency that would justify suspending public notice. Emergencies must be both unforeseen and require immediate action. The open meeting law covers when meetings can be closed off to the public. Again, as advisory boards, I don't think you'll come across any situations where you must go into executive session to discuss matters. If you do, it's likely to be to consider the character, misconduct, competence, or health of an individual. It covers what types of records must be kept, and that includes minutes. It also covers how the law is enforced. How is the law enforced? Well, to begin with, any action taken in violation of the open meeting law is considered void, as if it didn't happen. But persons who have a grievance under the open meeting law can file a lawsuit to enforce the law, or that they can complain to the Attorney General. The Attorney General's office is specifically tasked with enforcing the open meeting law. and they can bring a civil action to enforce the law or file criminal actions to punish for a violation of the law. They also issue both formal and informal opinions to provide guidance on following the law. The Attorney General's office has looked into town advisory boards several times in the past. In fact, just last year, the Enterprise Town Advisory Board was looked into by the Attorney General's office. The complainant submitted a very long complaint that was rather complicated and ambiguous. Ultimately, it came down to a question of whether or not the Town Advisory Board was required to put something on the agenda that this person wanted to have placed on the agenda. And the Attorney General's office rightly found that that's not a violation of the open meeting law. The public are not required under the open meeting law to have anything considered by the Town Advisory Board. There's such thing as the Nevada Open Meeting Law Manual, and it's a very good source for explaining the law. It covers the law extensively, the interests, as well as opinions and analysis of the law. If you don't have a copy, it's really easy to find. You could just Google it, Nevada Open Meeting Law Manual, it pops right up. But in my handout, I've also provided a link, so you can copy and paste that if you want to. It's updated fairly regularly, and as I said before, it contains the law and, most importantly, analysis on how to follow it. So it provides very good direction. Now that Aaron Ford is our Attorney General, I'm so sure he'll soon have an update so they can get his name on this booklet. What are meetings covered by the Act? That's not necessarily an easy question. Clearly, it includes the meetings that you have that are noticed to the public and where you sit down and discuss everything. But meetings can also cover other things. The definition that's provided for meetings is about a half a page long with small print. So as I said, it can be pretty complicated. Lectures such as this are generally excluded, as are social functions. But if you have a quorum at such meetings and you start discussing business, you would end up violating the open meeting law. So no talking business right now. And for there to be a meeting, there must be a quorum. What is a quorum? A quorum is a simple majority of the membership and the necessary of board members to act upon a matter. As I said, I was asked to spend some time discussing absences, vacancies, and abstentions in relation to the quorum requirement. Absences are the measure against which you compare the quorum requirement. If there are too many absences, there won't be a quorum. Vacancies are different. Vacancies reduce the membership of the body so that the quorum requirement would be less than it otherwise would be if you had a full number of members serving on your board. So if you have a 5-member board, 5 members who are supposed to be on the board, but you only have 3 people on the membership, the quorum requirement would be 2 as a simple majority instead of the 3 as it would be if there were 5 members on the board. Yes. Yes, sir. Well, if there's 4, there wouldn't be much difference. The simple majority would still be 3, as it would be with 5. If there were 2 members on the board, the quorum requirement would be 2, because it's a majority, and not a simple 50%, but it has to be more than 50%. It's my understanding that there's at least one board that only does have 2 members, so it's going to require unanimous appearance, unanimous voting to get anything accomplished on that board. Abstentions can act as either absences or vacancies. depending upon whether or not the abstention is required because of a conflict of interest. If the abstention is not required, it acts like an absence. And if the abstention is required, it acts like a vacancy. Who makes the determination as to whether or not an abstention is required? That would be the person who makes the disclosure and has the conflict of interest. And generally, it'll be up to the chair to decide whether or not that's a valid abstention, so as to determine whether or not there's a quorum for the required vote. There's also such a thing as what is called a walking quorum, which is a series of meetings that individually don't have a quorum, but collectively do have a quorum. This law was enacted because there were abuses where people were intentionally trying to avoid the quorum requirement and still deliberate collectively, from going from one person to another, discussing the matters. So if you go around talking separately with other board members, you can create a walking quorum. Such meetings can be in person, by face-to-face talks, but they could also be done over telephone calls, emails, chat rooms, and such. In such forums, you have to watch out that you don't collectively deliberate with a quorum. Social media. Social media can be a useful tool, but it could also be a problem. Don't be a troll. Social media is good for making announcements, but it's not very good for debate. It's very easy to be misunderstood and be perceived as a troll. Such things as even typing in all caps can be offensive to some people. The major danger of using social media is reducing your credibility because of the easy way you're perceived to be stating things improperly. And if your credibility is reduced, people will eventually disregard what you have to say, and then there won't be much point at being on your advisory council. And as I said before, in social media, you can even create a walking quorum. For social media, the buzzword is discretion. Discretion is strongly advised. When you talk about matters over which you have advisory business, in accordance with the legislative intent, you should save it for the sit-down meeting that's been publicly noticed. Agenda.
I've got a question.
Yes.
So I've been on the other side, and now I'm a new board member. And we have a social media in Laughlin. We have a social media in Laughlin called Laughlin Buzz. And I always like to tell what's happened after the meetings, you know, what people missed because they didn't come. As a board member, can I do that now?
Yes, you can, but I would advise against getting into discussions about that after you already post what has been
No, I just tell like a general, this is what happened, you missed this, the police reports and all this other stuff, and just keep it real general?
Yeah, that's fine.
Okay, good. Thank you.
Sure. Agenda. Agenda are one of the most important parts of the open meeting law. Agenda are not about primarily letting board members know what they're going to be discussing at the meeting. It's primarily about letting the public know what's going to be discussed so they can decide whether or not to attend and to participate in the discussions. And for that reason, you must stick to the agenda. It's a violation of the law to take actions or deliberate on matters that are not on the agenda. As I said before, emergency exceptions probably are not going to apply. Matters brought up in public comment should not be acted upon or deliberated upon. Instead, if it's something that you want to act or deliberate on, it should be placed upon the new agenda.
Steve, you got a question?
Yes.
Can a board limit public comment to just the before and after sections of the agenda, unless there's a public hearing?
Yes. What is required for public comment is that there be an item placed for public comment at the end of the agenda, and either a public comment period at the beginning of the whole agenda or before each item of consideration.
Thank you.
Sure.
At the end of the meeting, are you allowed to, if a person requests that they want something on the agenda for next time in the public comments, does it have to go on the agenda? Who decides if the people really want it? Who decides that?
That's up to the combined decision of the chair and administrative services. As I said before, the public is not entitled to have matters placed upon the agenda, but it can be done. That's covered in your bylaws. Because of inconsistent practices in the past and legislative direction calling for uniformity of administration, the Board of County Commissioners has directed that all town advisory boards and Citizens Advisory Council follow a uniform agenda format. So now staff strictly control the agendas. Agenda items must be clear and complete, and that's sometimes a difficult standard to reach. But generally, generalities and vaguenesses must be avoided. A good agenda item will generally be pretty long and packed full of information so that the public can make an informed decision on whether or not they want to attend the meeting and participate in the discussions. However, sometimes general terms in the agenda cannot be avoided because of unforeseen circumstances. In such cases, they should be as limited as possible and be limited to information items instead of matters over which you'll take action or deliberation. Agenda items must indicate whether they're going to be for action or discussion. The agendas must spell out any rules you have that limit public comment, which is why they all state that the public can only speak for 3 minutes at a time. They must indicate the time, place, and location of where the meetings will be held and the posting locations of the notices. They should also have a statement about providing assistance to people with physical disabilities. Public notices of the agenda must be posted at least 3 days in advance of the meeting in four locations, 3 prominent locations, plus the office or the location where the meetings are held. They must also be provided individually to persons upon request and posted on the internet if possible. The situation with having 4 locations just came up last week. Megan Halser had a situation with Mountain Springs where one of their posting locations, a mailbox cluster, had been removed because of the widening of a highway. And so she was had a rather dilemma as to what to do about that. I had to inform her that the meeting couldn't take place legally unless she found a new location, and had some suggestions about what to do about it. And she got creative and came up with a new location to post the agenda along the NDOT property up there. Mountain Springs is a small community, so there's not very many places where you can post an agenda. The agenda and backup material must be provided to the public at or before the meeting upon request. Bylaws. every board gets to review the bylaws and, if necessary, make changes for internal matters. The bylaws cover matters that are internal and those that are non-internal to the operation of the board. So changes can be made to change the meeting dates that you have, which are covered in the bylaws. The core of bylaw authority is for internal matters relates to parliamentary procedure. Functionally, whether or not you have to follow Robert's Rules of Order or something more relaxed. Understand there may be a question about that?
Yes, in the Laughlin bylaws, there is no provision for amendment, but in the County Commission handbook that we just received, the very last item in the book is the procedure to amend, which would take precedent.
I believe that you'd follow the procedure to amend set forth in the county's handbook, the Board of County Commissioners handbook. But any amendment would require review by staff and the district attorney's office so that we can ensure that there is a uniform format of administration. I hope that answered your question.
So the town board makes the amendment and then submits it through the town manager to administrative services and to you for approval?
Yes, that would be correct.
Thank you.
There was another question over here.
Yeah, a couple of things. On your parliamentary authority, you list the most current version or edition of Robert's Rules of Order. I'm assuming you mean Robert's Rules of Order newly revised. That's revised basically every 10 years. But there's also many current editions of Robert's Rules of Order Simplified, Robert's Rules of Order Condensed, Robert's Rules of Order for Dummies, Robert's Rules of Orders in English, in plain English. And the reason I'm assuming newly revised, because in your voting on page 7 in your book, you talk about the chairman of the board having the same rights as any other board member to vote, make motions, etc., which is under procedure for small boards in Robert's Rules newly revised, but not so in many of these other simplified versions of Robert's Rules of Order. And I know a lot of people in organizations I worked with that have smaller entities and their own bylaws, they go out and buy the cheapest Robert's Rules of Order, which many of this wouldn't follow. So I think that might be something you want to look at and making sure you put Robert's Rules of Order newly revised. And then also I see in here not having a second to make a motion. And that concerns me because the main purposes for having parliamentary procedure is to ensure majority rule, protect the rights of the minority, even those who are absent, by not moving past the scope and notice of an item on the agenda, because otherwise they may have been there, and most importantly, to facilitate the transaction of business. And I bet everyone in here have had those meetings where discussion goes on and on and on a motion. And if you allow a motion to go forward and discussed without a second, the purpose of a second is if no one else seconds that, that's telling you that that motion would fail because no one else thinks that's important to be discussed. So I would just like to understand why that's in there, that a motion would not be seconded.
I think the reason is to keep the operation of the Rules of Order as simple as possible. And in that regard, I think there's some inconsistency in the bylaws with respect to following the Robert's Rules of Order latest edition without specifying which type of orders and following the Board of County Commissioners procedural handbook. Generally, such meetings do not require the complicated aspects of Robert's Rules of Order, and generally it's a collegial atmosphere. But in cases of disharmony on the board, it may be necessary to follow the precedence of motions set forth in Robert's Rules of Order. And with respect to there being a second, it should be noted that the chair can also second the motion and call the motion based upon that.
Well, that's the beauty of procedure for small boards.
Yes.
And then on the amendment thing, because in here it said that amendment could be made, I think, at any meeting and then voted upon at the succeeding meeting. And if notice is only given 3 days before a meeting, that doesn't seem like enough notice and particularly if then it has to be approved by the commission. So could we get more information on how to amend those bylaws and follow all the recommendations that need to happen with the county commissioners?
I'd have to look into that further to let you know. The bylaws reiterate or make reference to the NRS and the Clark County Code. Those are not really internal matters that can be amended. They're not really necessary to be in the bylaws, but they are helpful to have for reference purposes. For example, the bylaws repeat the references to the ethical obligations. It's always good to reinforce the idea that you must act ethically. But they also make reference to Clark County Code 3.01, requiring removal of members for 3 unexcused absences. An absence is unexcused if you do not let the chair know in advance that you won't be attending the meeting. And removal is mandatory under that code section. So make sure you attend the meetings or let your chair know that you won't be able to attend the meetings. The bylaws also cover appointment of officers and the methods of resignations. They also specify that special meetings can be called by the chair or when necessary. This issue came up recently where the chair had called a special meeting and it was called off by the liaison unilaterally without discussing with the chair. I was asked whether or not that was permissible and who gets to call off such special meetings. Unfortunately, the answer is not addressed in the laws or the bylaws. So my advice is under such circumstances that it be a joint decision of the liaison and the chair, and that they cooperate in reaching such a decision.
And if there's conflict?
Well, then I think mediation would be appropriate. Getting some third person to help resolve what would be most appropriate.
Usually it's an emergency where you're having a special meeting.
As I said, mediation would probably be most appropriate. Finally, who can put matters on the agenda? The bylaws specify that can be the Board of County Commissioners, Administrative Services, Comprehensive Plannings, or any member of the Town Advisory Board or Citizen Advisory Council. As I said before, the public is not entitled to have matters placed upon the agenda, but it can be done as the coordinated decision of the chair and Administrative Services. That again presents the possibility that there may be a conflict between those two, but cooperation is advised. Are there any more questions? No? Well, I'm sorry, but my presentation is going to be rather short today. I don't have more to discuss. I thank you for listening to me, and I appreciate your being here today.